Hello there and welcome to Court This Week. I'm Dina Osha. In this special edition, we bring to you stories of legal proceedings from courts, from lower and subordinate courts to high courts and Supreme Court. We bring a selection of major legal proceedings which headlines this week. In the next half an hour, we will also inform you and update you of all the important proceedings from the week. So let's start Courts This Week. The Supreme Court has severely castigated the petitions who have alleged partiality and favoritism in the registry. The bench told the petitioner that being a member of the bar, he ought not make such allegations against the registry. Supreme Court dismissed the petitions and imposed a cost of ₹100 on petitioner.
The Supreme Court dismissed a petition alleging partiality and favoritism in the listing of matters on the part of the Apex Court Registry. While doing so, the court imposed cost of ₹100 on the petitioner for seeking a direction to the Secretary General and the Registrar to not give preferential treatment in listing of cases. The order passed by two-judge bench of Justice Arun Mishra and Abdul Nazir came in plea filed by Advocate Reepa Kansal, who alleged partiality and favoritism in the Supreme Court Registry with respect to listing of matters. The bench told the petitioners that being a member of the bar, he ought not make such allegations against the registry. The court has reserved its order in the matter on June 19th. The bench had observed then that this was unnecessarily allegation. The court had batted for the registries of the Supreme Court as well as the High Courts, saying that they were putting in a lot of hard work to ensure a smooth process for the lawyers and litigants. The petitioner should have been responsible before making such allegations, the court observed. During the hearing, the court had also noted that the registry is a part and parcel of the Supreme Court and not subordinate to the judicial side. Bureau Report.
Before the Delhi High Court, Solicitor General Tushar Mehta raised strong objections to the allegation made against Home Minister Amit Shah in the matter concerning the violence that took place in Jamia Millia Islamia in December last year. The court noted in the order that the petitioner is willing to expunge the said allegations from the rejoinder.
During the hearing on a group of petitions seeking independent inquiry in the violence that broke out in Jamia Millia Islamia University last December, Solicitor General submitted before the Delhi High Court that direct allegations against the Home Minister Amit Shah are irresponsible statement and should not be allowed by the court. While addressing the division bench of Chief Justice D.N. Patel and Justice Prateek Jalan, the Solicitor General submitted that the allegations made against the Home Minister in the rejoinder amount to irresponsible pleading by the petitioners as they are not backed by substantive evidence. The Solicitor General was responding to the rejoinder filed by one of the petitioners, Nabila Hassan, which states that the Home Minister himself gave order to the Delhi police to mercilessly beat up the students who are carrying out a peaceful march. Solicitor General asked the court to deal with such allegations seriously. He said, "Constitutional functionaries should not be maligning like this. Irresponsible pleading are becoming the order of the day. Such statements might look good in public speeches but not in affidavits submitted before a constitutional court. Article 226 of the Constitution cannot be invoked for such substantiated claims." After taking these objections into consideration and posing the same to the petitioner, the court noted in the order that the petitioner is willing to expunge the said allegation from the rejoinder. The petitioners are directed to submit a consolidated list of issues to assist the court during the proceeding. The said list is also supposed to be circulated among the petitioners and must be served to the other party before the next date of hearing. The case pertains to violence that broke out at the campus of Jamia Millia Islamia University last December. While the police claims that the force used was proportionate to the violence committed by the mob, there are many students who are severely injured and are seeking registering of FIRs against the erring official as well as compensation for their injuries. Bureau Report.
The Supreme Court has set aside the order passed by the Delhi High Court calling for an affidavit from the National Investigation Agency or NIA over the Gautam Navlakha's shift from Delhi to Mumbai. The court also directed that the remarks made by the Delhi High Court against the NIA be expunged from the order. The top court held that the case now falls under the jurisdictions of Bombay High Court. As such, the Delhi High Court shouldn't have entertained the plea.
The Supreme Court has cancelled an order by Delhi High Court in Navlakha case. The order was passed by a bench of Justice Arun Mishra and Naveen Sinha in NIA's plea challenging the Delhi High Court order, which had sought record of the judicial proceeding concerning Navlakha before Special Court in Delhi and Mumbai in relation to the Bhima Koregaon case. The court said that Delhi High Court ought not have entertained the interim bill plea filed by civil rights activist Navlakha in the Bhima Koregaon case, given that the case now falls under the jurisdiction of the Bombay High Court. Solicitor General Tushar Mehta argued that the High Court ceased to have jurisdiction in the case after Navlakha was produced before the Mumbai court via video conferencing and was subsequently placed under remand by the orders of the special court there. He also pointed out that all the other accused persons in the Bhima Koregaon case are in Mumbai. Appearing for Navlakha, senior advocate Kapil Sibbal questioned how a petition under Article 136 could lie against an order by the High Court merely calling for an affidavit. The bench, however, raised the question as to why the Delhi High Court entertained the interim bill plea filed by Navlakha when the court was expressly informed of the case now being in Mumbai's jurisdiction. Justice Sinha observed that Navlakha should have moved the special NIA court under Section 43 of the Unlawful Activity Prevention Act UAPA. The court then proceeded to allow the petition filed by the NIA and set aside the order passed by the Delhi High Court. The court also directed for the remark made against the NIA to be expunged from the order, while clarifying that no aspersions were being cast on the judge who passed the order. The Delhi High Court May 27th order was passed after Navlakha was taken from Delhi's Tihar jail to Mumbai, challenging the High Court's order as being patently without jurisdiction. The NIA had moved the Supreme Court, and on 2nd of June, a bench headed by Justice Mishra issued notice to Navlakha on the same. Bureau Report.
The Supreme Court has pulled up the central government for its lackadaisical approach to give permanent commissions and command posts to the eligible women officers in the army. The court has demanded strict follow-up of its order and has given centre 1 month time to implement orders.
The Supreme Court has told the central government that they must make a complete compliance and not just substantial compliance with the court orders to give permanent commissions and command posts to eligible women officers in the army. Owing to the COVID-19 pandemic, it gave government 1 more month to implement its order while taking a record on statement that the directives will be complied with in letter and spirit. A bench headed by Justice D.Y. Chandrachud took exceptions to the centre application, which stated that efforts are being made for substantial compliance with the direction issued by the court in its February 17th verdict. The bench response came after senior lawyer Meenakshi Lekhi and Meenakshi Arora expressed their apprehensions regarding the manner in which the government was trying to overreach the court orders. The lawyer, appearing for the women officers, contended that the criteria of physical standard that were discontinued by Army in 2011 have now been reintroduced only to deny benefit of permanent commission to women officers who have been in service for more than 10 years. They brought it back on the premise of gender parity only to defeat the purpose of this judgment, thereby compelling a 40 or 45-year-old women officer compete with their male counterparts in terms of physical standard, they said. On this part, Subramaniam assured the bench that there is no attempt to overreach the orders of the apex court and that the final executing orders will be issued by the government at any time now. The bench then took on record Subramaniam's statements and gave them 1 more month to implement the order. In its application, Ministry of Defence had asked for 6 extra months from Supreme Court to grant permanent commission to eligible women officers in the army and make provisions for command posts for them. The application by the centre underlined that it was not possible to comply with the court's order owing to the COVID-19 pandemic, which crippled the administrative functioning of the ministry as well as within the army. Bureau Report.
In the case of the spread of coronavirus amongst the minor girls in Kanpur shelter home, the apex court has asked the Uttar Pradesh government to file reply. Earlier, the court has prepared a questionnaire for the states to answer. Some states are yet to file their replies and the court had given them time to file till Friday. In April, the Supreme Court took suo motu cognizance of the potential spread of the COVID-19 in shelter homes and felt the need to pass the direction to protect minor lodged there. In the order passed by the bench of Justices L. Nageshwara Rao and Deepak Gupta, the court said that the direction passed are in line with the current available information regarding preventive measures. However, considering the dynamic nature of the situation, the court has also asked the state departments and concerned authority to keep abreast with the latest information and advisories.
The Supreme Court has directed Uttar Pradesh government to file an affidavit in relation to the spread of COVID-19 among 57 minor girls in a shelter home in Kanpur. The bench of Justices L. Nageshwar Rao, Hemant Gupta and S. Ravindra Bhatt took stock of news reports highlighting the spread of COVID-19 among minor girls lodged in a state-run shelter home in Kanpur. It asked Counsel for the State, Advocate Garima Prasad, to take instructions on the issue and file an affidavit. Reports suggested that some of the girls in the shelter home who tested positive for COVID-19 were pregnant, while one is even HIV positive. This issue was also raised in an application filed before the Supreme Court last month. Aparna Bhatt, who is an amicus curiae in the case, seeks implementation of court's guidelines as regards the prevention of spread of COVID-19 in childcare institutions. The court also followed up on the spread of COVID-19 among children in one of Chennai's state-run shelter homes. Court was informed by Tamil Nadu Council that all children who had contracted the virus have recovered and have returned to the shelter homes in compliance with the court's order passed in June. A detailed questionnaire prepared by Justice Ravindra Bhatt was required to be responded to by all states and union territories. The questionnaire was prepared in relation to the guidelines laid down by the Supreme Court in its order passed on April the 3rd for containing the spread of the contagion in children's home. However, several states were yet to file their replies. The court granted them time to file the requisite response. The court also appointed Advocate Gaurav Agarwal as amicus curiae in the case to assist the court and directed all states to submit their responses to him. In April, the Supreme Court took suo motu cognizance of the potential spread of COVID-19 in shelter homes where children are lodged as per the Juvenile Justice Act. The court said that it felt the need to pass certain directions for ensuring the well-being of these children. Bureau Report.
Clarifying that its June 29 stay order only pertained to 50% horizontal reservations for the Delhi locals, the Delhi High Court directed National Law University Delhi to issue an addendum to its admission notification. In its revised admission notification dated June 30, NLU Delhi has removed 50% horizontal reservations for the local as well as 22% reservation for the OBC in Delhi region and 10% reservation for the EWS.
Delhi High Court has allowed the National Law University Delhi to correct the error of removing vertical reservation for OBC and EWS categories in its admission notification and place a revised notification before the court. While noting that the university has misinterpreted the order of the court dated 29 June, wherein a stay was imposed on 50% domicile reservation, the division bench of Justice Hima Kohli and Justice Subramaniam Prasad clarified that the said order was only restricted to domicile reservation and had nothing to do with the vertical reservation. The order has come in an application moved by Delhi government before challenging the admission notification issued by National Law University Delhi so far as it eliminates vertical reservation for other backward classes, OBC and economically weaker section EWS categories. While rapping the university for misinterpreting its order dated 29 June, the court said, "You have squarely botched up the order. You are having a selective reading of your order as per your assumptions and creating a mess for the students. We expect better interpretation of orders from law school. You have chosen to undo things that shouldn't have been undone. Meanwhile, NLU Delhi informed the court that if they allow vertical reservation for aforesaid categories, they won't be able to provide hostel accommodation to all BA LLB students as there are infrastructure constraints. The university, however, did admit the fact that it had misunderstood the order of the court and that it is willing to issue a fresh admission notification within a week. The Delhi government had submitted that the decision of the university to eliminate 22% reservation for OBC and 10% reservation for EWS in its admission notification released on 30th June is not only the incorrect interpretation of the court's order dated on 29th June, but it also goes against the university constitutional and statutory obligations. It was submitted that the present writ petition only concerned within the 50% domicile reservation and had nothing to do with the vertical reservation for OBC and EWS categories. It was argued in the application that the university is statutorily bound to provide vertical reservation to OBC under Central Educational Institution Reservations in Admission Act 2006. Bureau Report.
Hearing a plea to expedite disposal of the cases related to foreign tabligis, the Delhi High Court has given a list of suggestions to fast-track the matter. The suggestions pertains to, among other things, segregation of cases and batch-wise hearings.
The Delhi High Court has come up with certain suggestions on managing the cases filed against foreign nationals for their alleged participation in the Tablighi Jamaat event that took place in Delhi in violation of visa rules. The order has come in a bunch of writ petitions seeking the earmarking of a designated court to try and adjudicate the cases filed against foreign nationals related to the Tablighi Jamaat event. The court observed that it has been stressed before this court that while many of the accused persons would be willing to plead guilty or enter a plea bargain in order to seek early closure of the cases so that they may return to their respective countries, if left unguided, the process may take a very long time. Based on the submissions made by all parties, the court laid down the following suggestions to expedite the adjudication of cases pending against the aforesaid foreign nationals. CMM may first post all 48 charge sheets and 11 supplementary charge sheets stated to have been filed on the same date for a case management hearing. At this hearing, the CMM may divide the cases into batches and sub-batches according to the nationality of accused persons and or offences alleged or on some other rational and useful basis. Secondly, after cognizance is taken at the appropriate stage, the CMM may segregate matters after eliciting responses from the accused person as to whether they propose to plead guilty, to enter plea bargain, or to claim trial. Thirdly, cases where accused of pleading guilty or entering plea bargains may be disposed of first. Fourthly, for each of these stages, the CMM may designate a specific date and time when exclusively these matters would be taken up, which could even be a non-working day, so that adequate time and resources could be devoted to facilitate expeditious disposal. Lastly, the embassy or High Commission concerned may be requested to arrange for the appearance of accused persons via video conferencing and also for identifying the accused person as per official records or documents. The court has also kept the matter pending in case any further directions or guidance is required to bring these matters to a conclusion at the earliest possible. Bureau Report.
Hearing a suo motu PIL on the migrant woes, the Supreme Court has asked the Maharashtra government to file an affidavit on the same. The Apex Court said that you cannot say everything is fine in the state of Maharashtra. The Supreme Court directed state to find out problems related to migrant crisis. The court passed this direction after taking note of an application stating that a certain section of migrants are still waiting to be transported back to their home states. In the last hearing, the court has made it clear that as per its previous order, migrant workers stranded amid the COVID-19 pandemic were mandatorily required to be transported to their hometowns within 15 days.
The Supreme Court has directed the Maharashtra government to find out the problems faced as the result of COVID-19 migrant crisis. The court passed this direction after taking note of an application stating that a certain section of migrants are still waiting to be transported back to their home states. The bench of Justice Ashok Bhushan, S.K. Kaul and M.R. Shah passed the direction while hearing the suo motu PIL on the migrant crisis affected by the COVID-19 pandemic. At the start of today's hearing, Solicitor General Tushar Mehta, appearing for Maharashtra, made submission on the national testing policy and a COVID-19 containment plan. He said that he would serve copies of the state affidavit filed in this regard to the opposing counsel. Mehta also clarified that the state has filed a response to the application filed by Centre for Public Interest Litigation. Senior advocate Abhishek Manu Singhvi suggested that the centre come up with constructive scheme for insurance for migrants, he said. We also need a work plan and centralized system to rehabilitate the migrants. Registration of migrants need to be insisted upon. In response, Solicitor General Mehta said that the reply filed by the state would address these concerns. When the bench pointed out that there were still migrant workers in Maharashtra who wanted to be transported, S.G. Mehta said. The migrants who wanted to leave earlier have now decided to stay back as the state opened up employment opportunity. From 1st May, around 350,000 workers came back to work again. Justice Bhushan at this point noted, when you are the state, it's your responsibility to find out which group of migrants are getting food, etc. Your affidavit says food is being provided to migrant workers. Observing that the centre was treating this matter as adversarial litigation, Justice Shah asked Mehta to file a proper affidavit. Justice Bhushan then said, you cannot say everything is fine in the state of Maharashtra and that you are providing food and transport. In response, S.G. Mehta said, whoever wanted to shift has been shifted. Those who were stranded and went back are not getting jobs as per their skills. The bench then proceeded to direct the Maharashtra government to find out the problem arising out of the migrant crisis. The state is required to file an additional affidavit clarifying its position on the stranded migrants. On 26th May, the Supreme Court, while taking suo motu cognizance of the migrant crisis, said there have been inadequacies and certain lapses on the part of the central and the state government in dealing with the issue. Bureau Report.
Well, that's all in court this week. Thank you so much for tuning in and keep watching APN and stay safe.